Good afternoon, everyone. Thanks for joining our today webinar on the Vietnam's 2025 amended IP law, with a focus on practical business implication, especially around AI, digital platform enforcement, and procedure reforms. My name is Diệp, a lawyer from Tilikian Gibbons, Vietnam, based in Hanoi. My area of practice include IP enforcement and commercialization. Joining with me today is my colleague, Ms. Hằng. Let's welcome Ms. Hằng.
Hello, everybody. I'm Han from Siliki and Gilbin. Same as Miss Yip, we are based in Hanoi, and I am currently working in IP enforcement team. It is such a pleasure for me to see you all here today with us, and thank you very much for joining with us today. Before we begin, just a few housekeeping notes to help the sessions run smoothly. This webinar is being recorded. All participants are currently on mute to minimize background noises. You are encouraged to engage with us by asking questions. Please use the chat function located at the bottom of your screen. All questions will be addressed at the end of the session. If time running out, I'll follow up via emails. Your feedback is very important to us. At the end of the webinar, a QR code will appear on the screen. Please take a moment to scan it and share your thoughts. With that, let's get started. I will now hand it over to Ms. Yip to begin with the presentation. Please, Ms. Yip.
Thank you, Han. Let's get started with our overview on outline for the today webinar. Our goal today is to help you to understand what amendments are there, why it matters, and how businesses should respond. We will begin with a brief introduction and context for the 2025 amended IP law before going through details major changes in IP protection and IP enforcement, as well as liability of ISP under the new law. And we conclude our webinar with a practical checklist for businesses. The Q&A section is going to be at the end of the webinar. Let's get started with an introduction of the new amended IP law. Vietnam's IP law was enacted for the first time in 2005. Over 20 years, it has been amended and supplemented 4 times. Each major amendment responded to external pressure or economic transformation. For example, the 2009 amendment was triggered by Vietnam's accession to the WTO, while the amendment in 2019 and 2022 was driven by Vietnam's commitment to international agreements such as CPTPP and EVFTA. For the 2025 amendment, it is triggered mainly by the rise of AI, data-driven technologies, growth of digital platforms, and Vietnam's ambition for a creative and innovative economy. Against this background, the 2025 reforms aim to bring the Vietnam's IP law to align with AI and data-driven innovation, modernize the IP system, streamline procedures to reduce administrative burden, and significantly strengthen digital and online enforcement mechanisms. In the webinar today, we are unable to introduce to you all changes of the new law. Instead, we will focus on several key policies that we believe would be relevant to businesses. The key change include how the new law recognizes IP issues arising from AI-generated output, the introduction of text and data mining framework, procedure reform, and an upgraded enforcement mechanism. The law itself set direction. However, the real impact of the new law comes from implementing decrees and circular. To date, several decrees was issued and took effective together with the amended IP law on the 1st of April 2026. while other decree will be adopted in the coming weeks. Now let's move into detailed amendment under the 2025 IP law, where we focuses on three main areas, including AI-related issues, procedure reform, and some notable amendment to IP rights. We begin with AI-related issues. Under the 2025 IP law, Vietnam formally acknowledged for the first time the existence of IP issues arising from AI-assisted output. It means that the amended framework makes it clear that output created with the assistance of AI can fall within the IP system. However, that raises a set of core legal questions as to who owns the AI-assisted output. Can AI itself be an author or an inventor? And what level of human input is required for protection? And the answer is Vietnam follows a global trend to adopt a human-centered approach to AI-generated IP. It means that while AI-assisted creation is recognized in principle, IP protection ultimately depends on significant human contribution. In the other words, AI may assist the process, but human involvement remains the decisive factor for IP ownership and protectability. And only human can qualify as author or inventor. And the next question is, when is AI-assisted IP can be protectable? In general, for patent, industrial design, and copyright, it usually requires a human significant contribution in creating process, which usually include providing ideas, controlling and modifying AI input, output, or make creative decision and design final output. For trademark, trade name, geographic indication, and trade secret, the IP created with AI assistant are fully protected if they meet standard requirements of registration and no additional human authorship is required. There's an important note here is that the burden of proof belong to the applicant or the IP right holder. It means that businesses must be able to explain and evidence the creation process. In practice, documenting human contribution at each stage of AI-assisted creation is essential to support ownership and enforceability of IP rights. Another AI-related issue is the text and data mining framework. Under the Article 7.5 of the amended law, data mining, text and data mining is allowed for AI training if the data is lawfully published and publicly accessible, and the use of those data must not unreasonably prejudice to the IP right holder. The policy goal is to strike a balance between encouraging AI development and protecting IP rights. However, there are several additional conditions under the Decree on Copyright for text and data mining activities. First, text and data mining is limited to non-commercial purpose only. Second, the use must not conflict or interfere with the normal exploitation of the copyrighted work. Third, the output generated by AI do not replace the normal market consumption of the copyrighted work. And importantly, the right holder retain the control in their copyrighted work. They may opt out and refuse permission for their work to be used in AI training. Therefore, in practice, it means that AI developer will still need to pay attention to right management, data sourcing, and opt-out mechanism. Now, I move to the next part of my presentation about procedure reform. Procedure reform is one of the most business impactful changes. The law now introduces a shortened timeline across IP prosecution and a fast-track examination mechanisms for selected cases. Under the new law, substantive examination timeline is only 5 months for trademark and industrial design application and 12 months for patent application. The deadline for opposition and response to office action are also reduced to only 2 months now. It means that for a smooth case, trademark and industrial design registration can be completed within around 6 to 7 months and slightly for more than 12 months for patent registration. In our view, this new timeline sounds very fascinating for businesses in securing IP protection in Vietnam. But at the same time, it could be a very big challenging for the IP office to follow that timeline. So we will see how it goes in practice in the coming time. One of the most business-friendly innovation under the new law is the new fast-track substantive examination pathway. The fast-track examination is now available for national applications in certain cases where it involves strategic technology or urgent circumstances, such as national security and defense need or national disaster or public health emergency. However, guidance for the fast-track examination is still limited. And this mechanism help business accelerate commercialization and enforcement by obtaining protection quite early in Vietnam. However, it also requires carefully preparation to meet stricter procedures and documentary requirements. Now we move to some other notable amendment to the IP right. First, the design protection is now expanded to protect partial designs as well as non-physical and digital design. The second amendment addressed overlapping IP rights. Under the updated law, it introduced clearer mechanism to deal with conflicts between multiple IP rights covering the same subject matter. Where the conflict arises, later arising rights may be terminated. This provides greater legal certainty and reduce the risk of abusive or duplicate registration. And finally, the law strengthened recognition of IP as a commercial asset. IP rights are clearly positioned as an asset and can be used for investment, capital contribution, and collateral in financing transactions. This aligns the IP framework with the investment law and enterprise laws in Vietnam and reinforce that IP right is a core business and financial asset. That is the end of my part. Now let's my colleague Thanh to provide you further information on IP enforcement.
Thank you very much, Zia, for your insightful and extensive overview of the IP amendment. Now let me share my screen. Okay, now we move on to the next section, which is focused on enforcement issues. The first section is ISP liability. As you can see, the heart of this change is Article 198B. Previously, this was a strictly copyright tool. Now, this article covers all IP. Trademark, design, patent, and plant variety protection now have the same digital enforcement weight as copyright. We finally have a direct, specific tool in the IP law to deal with any type of infringement occurring online. Also, by naming digital platform owner alongside with ISP, the law removes any doubt. For giants like Shopee, TikTok, Facebook are now recognized ISP with specific duty in cyberspace. Now, I would like to draw your attention to the new addition, Clause 5A. Looking at this new clause, you will notice that it contains a very heavy mandate. ISP and platform must implement IP, e-commerce, and cybersecurity measure. At this point, you're probably asking the same question as the platform are asking. What exactly do these measures look like in practice? Let me tell you that it is not just about one law. It is a combination of IP law with a new law on e-commerce and the law on cybersecurity, which both hit full force at the 1st of July this year. Now let's break down the specific requirement. First, let's take a look at the e-commerce prong. Under Article 17 of the new law on e-commerce, the measure mentioned in Clause 5A becomes very concrete. First is a KYC, know your customer requirement. Platform can no longer let anonymous seller trade. They must conduct electronic identity verification. For Vietnamese seller, they must at least provide their name and address, applying to both enterprise and individual. For foreign seller, their identity must be checked via legal documents such as passport. The next one is pre-display screening. This is a major shift. Platforms are now required to moderate and censor information before it goes live to prevent the sale of infringing products. As of now, maybe some of you might know that ISP does not conduct pre-check. They only conduct check when they receive report from buyer, IP owner, or a third party. The next one is mandatory automation. For the big platform, such as Shopee, TikTok, the law even stricter. They must implement automatic scanning system to detect, warn, and remove infringing content, and crucially, have mechanism to prevent repeat offender from coming back. And of course, platform owner are now jointly liable for compensation if they fail to implement this duty and it results in buyer damage. The second prong is cybersecurity. As you can see here, we're currently looking at the new law on cybersecurity and a draft decree on the prevention of cybercrime that would replace the decree number 25 from 2014. Now, because it's still in the draft state, the specific technical measures are not as specifically defined as the e-commerce one yet. However, this draft provides so many types of infringement for the digital age and define the act that platform would now proactively prevent, such as unauthorized live streaming, manufacturing, trading, advertising, or distributing counterfeit goods, or even failing to comply with takedown procedure, etc. And my advice here is clear. The platform must monitor this draft closely, and as it moves towards finalization, this decree will eventually dictate the specific measure that you need to apply to stay compliant. Finally, we have the IP prong itself. Currently, we have a very clear measure for copyright and related right. Under Decree 17/2023 and its amendment, the rules are crystal clear. It defines the legal liability of ISP and the specific notice and takedown procedure. If you are a copyright owner on ISP, you know exactly what tool you have and or what measures you have to take to enjoy the safe harbor. However, because as I said before, the Article 198B was recently amended to broaden the protection to all categories of IP. But while the law expanded, the decree asked you catching up. So unlike copyright, we don't yet have a specific detailed guidance for notice and takedown regarding counterfeit trademark or violation of patent invention on a digital platform. For those specific measures, we are in a wait-and-see mode for the amendment of Decree 99/2013, which governed the industrial property violation. That is all about ISP and the obligation. The second section is about enforcement action in general. First, let's take a look at Article 200. It shifts from naming specific agency like Inspectorate, Market Surveillance Agency, Custom, to the general reference of authorized authority and refer directly to the law on handling of administrative violation. This is kind of future-proofing. If the government restructure, we know that the Vietnamese government have been doing quite a lot lately, the IP law remain valid. In addition, we still have the court remain the sole venue for criminal and civil measure, and custom remain our border gatekeeper. Now is Article 202. As you can see, the court took his rule from 5 to 7 measure. We now have a zero tolerance policy. It's mandatory destruction of counterfeit raw material and even the machinery used to make them. The approach is much stricter than before. Finally, the addition of Clause 7. Now the court has a clear direct power to remove, hide, or disable access to digital content, account, and app. This gives the right holder the specific legal basis they need to find infringement in cyberspace. Here is the Article 205, and it's introduced a major update that significantly increased the cost of infringement in Vietnam. First, a look at the statutory damage cap under Clause 1D. Previously, the maximum was set at 500 million Vietnam dong. The new law has doubled to 1 billion Vietnam dong, which equal to 38,000 US dollar. It's not only raised the stake of infringer, but it's also provide a safety net for claim for IP owner. We know that in so many IP cases, proving the exact amount of material loss is with precise evidence can be extremely difficult. So this higher cap ensures that the right holder can still receive some compensation even when their specific losses are hard to quantify. And secondly, the law changed how we calculate the non-material damage. Instead of a fixed range of 5 to 50 million Vietnam dong, it now linked to the base salary, specifically 10 to 100 times the base salary. And this is the Article 207, as you know. So you can see that there's the act of the POIDD, that the court now can order hiding or temporarily disabling asset to URE account and app. As you might know, the legal process often moves too slowly for the internet. By the time a trial reached a final verdict, the pirate content or infringement had already gone viral, or the fraudulent e-commerce store had already completely scanned, disappeared. So with this new point, we can now freeze the infringement immediately. This is absolutely critical for stopping the viral spread of content and preventing fraudulent accounts from continuing their operation while the trial is still ongoing. Is effectively give us a kind of kill switch to stop the harm in real time. The final one would be in Article 211. We see an update to the list of prohibited action against counterfeit goods. Under Clause 1B, the law now explicitly adds storing to the list of punishable acts alongside with manufacturing, importing, transporting, and trading. This addition is a major help for enforcement authority during especially raid and warehouse inspection. From our own experience, we saw many cases when thousands of counterfeit were found in the warehouse and infringers just claimed that the goods were not intended for sale. So while this almost never works, sometimes it does slow down enforcement officer in their raid action. But that ends from now. That's the grey area is gone. The mere possession of counterfeit goods in a storage facility is now direct violation, and this will remove any ambiguity and should make warehouse raids much more effective. And here I'm showing you with the IP Enforcement Authority. For the administrative action, we still have the Market Surveillance Department, Custom, Police, IP Office, and the People Committee. We can see that IP Office now have the authority to address IP infringement under Article 6.3, Decree 189/25. However, in reality, IP Office has not used this authority yet because we need to wait for the amendment of the Decree 99, which governs the administrative violation in the field industrial property. The Enforcement Authority of Civil Action still remain just with the IP Court. Criminal action is the arrest with the police for the investigation, people procuracy for prosecution, and the court for judicial adjudication. Okay, so to wrap everything up, I will now provide a practical checklist and recommendation for business to navigate in this new legal amendment in Vietnam. Our first focus is internal strategy and compliance. You should start by reviewing your entire IP portfolio. Do not just look at traditional assets. Look for gaps in your digital assets, such as user interface and digital content, which is now easier to protect but more vulnerable than ever. Secondly, AI and data compliance. This is a major new area. You must identify the data set that you use for AI training and ensure that they come from lawful sources. It is also time to update your internal policy regarding how your team handle and attribute AI-generated content. Thirdly, optimize filing quality. Because the law introduced faster timeline and stricter opposition deadline, you cannot afford a sloppy filing anymore. Strengthen the quality of your dossier from day one, and I also recommend using the new fast-track examination option for your most critical or urgent strategic asset. Moving to the second part is about commercial and enforcement. First of all, our recommendation is update your contract. Your commercial agreement needs to catch up, including specific IP and AI clause that explicitly clarify ownership of AI-generated output. Do not leave this to the default interpretation of the law. Secondly, strengthen the enforcement readiness. As we always say to our client, actively monitor e-commerce platform and the internet are crucial to protect your business. And since the law now gives us clear digital measure, you should establish a clear process for content for infringement takedown. When you find infringement, you need to be ready to act immediately to stop it from going viral. Or better, let professionals like us do that for you. Finally, keep tracking the regulatory development. As I mentioned earlier, we are still waiting for the implementation guidance and the new decree expected in 2026. So your compliance framework should remain flexible enough to align with these upcoming changes.
Thank you very much for your time today, and we very glad to have you here with us.
Thank you very much for joining with us today. I hope that information is helpful for you. Thank you.